Have you ever seen a huge political scandal blow up, dominate every headline, and then just fade away? No one gets charged, no one's held accountable. You see a massive investigation, nonstop news coverage, and hear all these promises of justice. Then, crickets. It's not your imagination, and it's not some wild conspiracy theory. There are real, hidden mechanisms inside our justice system, legal loopholes and quiet policies that allow the powerful to make their problems disappear. These aren't the legal defenses you and I could use. These are escape hatches built right into the system, and they seem designed for a class of person most of us will never be. Today, we're pulling back the curtain to reveal the shocking ways political cases get dismissed. The first, and maybe the most powerful tool, is one that isn't even a law. It wasn't passed by Congress or decided by the Supreme Court. It's an internal Department of Justice policy, a memo from the Office of Legal Counsel, or OLC. For decades, the OLC has taken the position that a sitting president cannot be criminally prosecuted. So, what's the official reasoning? It comes down to the separation of powers. The theory is that a criminal trial would totally hamstring a president's ability to do their job, to run the country and command the entire executive branch. I mean, think about it. The Department of Justice is part of the executive branch. The idea of the DOJ prosecuting its own boss creates a weird constitutional paradox. This isn't about being above the law forever, but about temporary immunity while in office. The proper way to deal with a law-breaking president, according to this logic, is political. Impeachment by Congress, not indictment by a prosecutor. Now, this was always a legal theory, a DOJ policy, not a court-tested law. But in late 2024, that theory crashed into reality. After winning the presidential election, Donald Trump was facing two major federal indictments from special counsel Jack Smith, one for trying to overturn the 2020 election and another for mishandling classified documents. But on November 25, 2024, everything changed. Jack Smith filed motions to dismiss both cases. The court filings were blunt. Smith's team cited the DOJ's long-standing policy, arguing that because Trump was now the president-elect, continuing the prosecution was impossible. The Office of Legal Counsel had advised that the ban on prosecuting a sitting president was categorical, and they believed this applied even to indictments filed before the person took office. In the election interference case, Judge Tanya Chutkan granted the dismissal, but she made a critical distinction. She dismissed it without prejudice. A dismissal with prejudice means a case is dead forever. Without prejudice means the door is left open. The charges could theoretically be refiled once Trump leaves office. The documents case, which a different judge, Eileen Cannon, had previously dismissed on the controversial grounds that Jack Smith's appointment was unlawful, was also formally dropped when Smith's team withdrew their appeal. And just like that, two of the most significant federal prosecutions in modern American history evaporated. Not because of a jury, not because of a lack of evidence, but because of a decades-old internal memo. It shows how the voter's decision at the ballot box can become the final verdict in the courtroom, a mechanism completely unique to the political world. While the executive branch has its secret memos, the judiciary has its own powerful way of making political cases vanish. This isn't about one rogue judge, it's about something much bigger. In recent years, the Supreme Court has started to systematically narrow the definition of public corruption, making it drastically harder for prosecutors to even bring these cases. For decades, prosecutors used broad anti-corruption laws to go after politicians who traded their influence for personal gain. The idea was simple, a quid pro quo, this for that. A politician takes money or gifts, and in return, the gift giver gets special treatment. But starting with the 2016 case of McDonnell v. United States, the Supreme Court began to chip away at this framework. Former Virginia Governor Bob McDonnell was convicted of corruption after he and his wife accepted over $175,000 in loans and luxury gifts from a businessman. In exchange, McDonnell set up meetings for the businessman with government officials and hosted events at the governor's mansion. Basically, he lent the power of his office to help the guy's company. It seems like a pretty clear-cut case of corruption, right? Well, the Supreme Court unanimously disagreed. In a ruling written by Chief Justice John Roberts, the court dramatically narrowed what counts as an official act. They argued that just arranging a meeting, making a call, or hosting an event doesn't automatically qualify as a formal government act. To prove bribery under this new, higher standard, a prosecutor has to show the politician made an explicit decision or took formal action on a specific government matter that was actually pending before them. All of a sudden, a whole range of behavior that most of us would call corrupt, like selling access to powerful people, was much harder to prosecute at the federal level. McDonnell's conviction was thrown out, and the DOJ later dropped the case. And this wasn't a one-off. In Percoco versus United States, the court further limited who could be prosecuted for honest services fraud, making it tougher to go after influential private citizens pulling government strings from the outside. More recently, in the 2024 case Snyder versus United States, the court ruled that a key federal bribery law doesn't apply to gratuities. That is, thank you payments made to an official after they've already done something unless there was a pre-existing corrupt agreement. The combined effect of these decisions is huge. They've created a legal minefield for prosecutors. Now, politicians can argue they weren't selling a government action, just selling access, a defense that would have been laughed out of court a decade ago. It's a quiet, complex way political cases get dismissed, not with a bang, but with the slow, deliberate rewriting of the law by the highest court in the land. It's pretty clear the rules for the powerful are different. If you're finding this breakdown of the hidden legal system useful, make sure you subscribe and hit that bell. We pull back the curtain on these kinds of issues every week, and you don't want to miss what we uncover next. And hey, sharing this video helps more people understand how the system really works. Not every case ends in a dramatic courtroom dismissal. Some of the biggest political cases get resolved before they even start, through quiet agreements negotiated behind closed doors. They're called deferred prosecution agreements, DPAs, and non-prosecution agreements, NPAs. Think of them as a kind of probation for the powerful. In a DPA, the DOJ files criminal charges but agrees to put the case on pause. In exchange, the defendant, whether a corporation or a person, agrees to certain conditions. This could mean paying a huge fine, cooperating with investigators, and hiring an independent monitor. If they follow the rules for a few years, the government just drops the charges. No trial, no conviction, no formal admission of guilt. A non-prosecution agreement, or NPA, is even more secretive. Here, the government agrees not to file any charges at all. These are often just letters between the DOJ and a company, with no judicial oversight. So why do prosecutors do this? Officially, they say it's a useful middle ground. They argue a full criminal conviction of a major company could cause collateral consequences, like bankruptcy and massive job losses. They also use these deals to get cooperation against even bigger fish. But critics see a two-tiered system of justice. While a regular person has to plead guilty or go to trial, powerful players can essentially buy their way out of a criminal record. These agreements are most famous in the corporate world for things like massive fraud, but the principle allows prosecutors to claim a win while letting well-funded defendants avoid the career-ending stain of a conviction. The public hears about a big settlement, but what's often missed is the key detail. The case was dismissed, and no one was actually found guilty of a crime. There's one last, extraordinary way a political case can vanish, and it's a tactic straight out of a spy thriller. It's a high-stakes legal threat called graymail. Graymail is when a defendant in a case involving national security threatens to reveal classified information in open court to defend themselves. This puts the government in an impossible spot. Do they risk having state secrets, like intelligence sources or covert operations, splashed across the headlines? Or do they drop the case to protect national security? This is such a known problem that Congress passed a law in 1980 to manage it, the Classified Information Procedures Act, or CIPA. CIPA creates a process for courts to handle classified evidence in secret, pretrial hearings. A judge can decide what's truly relevant and maybe allow the government to provide unclassified summaries instead of the real documents. The goal of CIPA is to stop defendants from just demanding every secret file under the sun to force a dismissal. But here's the catch. If a judge decides a piece of classified information is essential for a fair trial, and the government still refuses to hand it over, the judge can dismiss some or all of the charges. This gives defendants who have dealt with state secrets incredible leverage. A former CIA director, cabinet secretary, or even a president can argue their actions were secretly authorized and that they need a mountain of classified documents to prove it. Just fighting over what's admissible can drag a case out for years. Prosecutors know that bringing a case against these figures carries the risk of gray mail. Sometimes, they might decide the risk is just too high and never file charges. Other times, they might be forced to offer a lenient plea deal to prevent vital intelligence from being compromised. It's the ultimate trump card for a certain kind of defendant, allowing them to use the government's own secrecy as a weapon against itself. The justice system is way more complicated than most of us think. If you want to keep exploring these hidden corners of law and politics, remember to subscribe and turn on notifications. We've got a lot more to uncover together. Let me know in the comments. Which of these escape hatches do you find the most shocking? So where does that leave us? How do major political cases just disappear? As we've seen, it's not always about innocence or guilt. It's about power, policy, and procedure. A case can vanish because of an old DOJ memo that shields a sitting president from the law, turning an election into a verdict. It can crumble because the Supreme Court quietly raises the bar for what counts as corruption, making it harder to prosecute powerful officials. It can be settled behind closed doors with a massive fine that substitutes for a criminal conviction. And it can be stopped dead in its tracks by the threat of gray mail, where state secrets become a shield. These are not loopholes for the average citizen. They are escape routes carved into the system for the powerful and the connected. They feed that nagging and often justified feeling that there are two tiers of justice in America, one for them and one for the rest of us. Understanding these mechanisms isn't about being cynical. It's about demanding transparency and accountability. It forces us to ask a tough question. If the system has built-in ways for the most powerful people to dodge the consequences, can we truly say that no one is above the law? That's a question worth thinking about.